Good
All
afternoon,
right, everyone,
Judge.
are you able to hear me?
I can hear you, Judge.
Oh, wonderful, thank you. Good afternoon,
Judge.
everyone. I apologize for the delay. I was having some problem with getting onto Zoom for some reason. This is the State Expedited Accusations calendar. I am Judge Melanie Williams. I want to advise all participants that this particular proceeding is being broadcast over the internet, live streamed and recorded. That means that any member of the public can log on and watch this particular proceeding. All defendants, you have an absolute right to remain silent. Anything you say regarding the facts of the case can and will be. You also have a right to an attorney at this proceeding. If you are driving, please make sure that everyone is in a safe location. And those who receive a signature bond today will be reset for the notice. Those who receive a surety or cash bond today will be reset to the SAP calendar on April the 7th. All right, who do we have first?
Oh, I'm sorry. Good afternoon, Your Honor.
Good afternoon, good to see you. What position do we have first?
Position number 3, Miss Pepco.
Pepco. Yes.
Position 3 and 4, Ms. Bepco. Are you Shannon Bepco?
Yes, ma'am.
All right, you have two cases, Ms. Bepco. Your first case is 22 CR 001705G, in which you're charged with simple battery family violence. And your second case is 22 CR 001707G, in which you're charged with obstruction of a law enforcement officer. I've advised you of your rights. Do you have any objection to a video hearing today?
No, I don't think so.
Okay, and can your attorney assist you today by video?
Yes, I'm using Mrs. Helen.
All right, thank you. Mr. Howard.
7 total. She was just arrested on the 3rd of this month for battery DV. That was a SOB jail. 2016 obstruction, simple battery against police out of Alpharetta. DUI marijuana possession 2016. Probation violation DUI 2014. That's it.
All right, thank you. And whose case is this for the state?
It's mine, Your Honor. Jordan Reiser here for the state.
Good afternoon, Ms. Reiser. Good to see you. What is the state's recommendation?
Yes, Your Honor. For the simple battery charge, simple battery family violence, the bond recommendation would be a $5,000 surety bond to have no further contact with the victim, Jack Bepco, Bepko, and to stay away from 630 Hopewell Downs Drive in Milton, as well as to have no drugs, alcohol, or weapons while out on bond. Your Honor, the reason for the state's recommendation, officers had responded to the incident location for a domestic dispute, and the victim spoke with officers and indicated that the defendant had pulled his hair multiple times. My understanding, the relationship between the two is that the victim and the defendant are brother and sister. Your Honor, based on her history, she was just arrested this year for battery family violence, as well as I'm showing 3 DUI convictions and 1 VOP. So the state believes that this 5K surety bond is reasonable in this case, Your Honor.
Can we go ahead and address the second case as well? What's your recommendation for the obstruction?
Is that on?
She may have froze.
Am I frozen?
No,
Okay, just making sure. Ms. Reiser, are you still with us? I think you froze for a moment. What's the recommendation for the obstruction?
Yes, Your Honor, can you hear me?
I can, yeah.
Okay, great. Sorry about that. On the obstruction, she currently has a bond set at $1,000 surety. The state believes that that's reasonable, as well as the same conditions, no drugs, weapons, or alcohol. This actually happened the subsequent morning when an officer, O'Neill, was taking her to the hospital. She refused to follow verbal commands while she was walking in, refused to let the officer put the seatbelt on her, and kicked the officer's door when he attempted to close it.
Okay, thank you. All right, Ms. Helen, good to see you as well. Been a long time.
It's been a long time, Judge. Good to
yes.
see you.
What
but
is
today
your recommendation?
My recommendation, first, I'm going to ask for a signature bond for Ms. Bepko, because currently right now she's 28. She is not working. However, she is a college graduate from International School of Skin. That is a cosmetology school to where she did attend. She is from Connecticut. However, she's been in Georgia the last 20 years. So I do think that makes her at least a resident of Georgia, and she has no children. At this time, she wanted me to let the court know right now, she is entering herself, as well as with the help of her parents, into a substance and residential housing program, as well as anger management program, because she understands how serious these charges are. When I spoke to her, we did speak of the other charge with, I think it's going to be her boyfriend, and this one is with her brother. We did talk about that these are serious charges. And again, Judge, that is why we're asking for a signature bond. And if your judge feels that she is not eligible for that bond, we are asking for a bond of no more than $1,000 for the simple battery. And again, to keep the battery, or to keep the bond as it is with the obstruction, for 1,000 surety, Judge.
Thank you, Ms. Helen. At this time, I'm going to sound for the victim, Jack Bepko. Mr. Bepko, you are not required to make a statement here today in court, but if you would like to do so, this is your opportunity to speak. Would you like, I see you on the screen, would you like to make a statement at this time, Mr. Bepko?
Me, Your Honor?
No, I think
Oh.
your brother is on the screen.
Oh, I see. Okay.
Please don't say anything. Please don't. Mr. Bepko, would you like to make a statement?
No, thank you.
Okay, thank you. You're not required to do so. All right, is there anything further from either the state or the defense at this time?
No, Your Honor.
Nothing from the state, Your Honor.
Ms. Helen, if I were to issue this stay away at this time, does your client have somewhere that they could stay temporarily? I feel that a cooling off period might be necessary in this case.
Judge, I currently have her address as a 630 Hopewell Dance Drive. I can ask her, Ms. Bepko, she's nodding her head. Do you have another address that you would be, yes, Judge. And I think either we can provide that to the court now, or
No, I think I am going to issue the stay away. I think a cooling off period is necessary. Okay, so for count one, Ms. Bepko is going to receive a $2,500 surety bond. She is to have no further contact with Jack Bepko, and she is to stay away from that address on Hopewell Downs. She is to have no weapons, drugs, or alcohol as a condition of this bond. And for count four, case for position 4, I'm going to lower that to a $500 surety with the same conditions, no alcohol, drugs, or weapons. All right, is there anything further from either party?
No, Your Honor.
All right, best of luck to you, Ms. Bepko. We can move to the next position.
Next position, number 10, Ms. Kennedy.
Okay, good afternoon. Are you Deshauna Kennedy? Please move quickly.
Yes, ma'am.
Thank you. All right, Ms. Kennedy, your case, I'm Judge Melanie Williams. Your case is 22 CR 0017048, in which you're charged with DUI, possession of an open container, improper or erratic lane change, actually 2 counts of DUI, 1 DUI less safe, and 1 with a concentration of 0.8 or more, with an offense date of March 24th. I've advised you of your rights. Do you understand them?
Yes.
Do you object to the video hearing or to your attorney assisting you today by video?
No, ma'am.
All right, thank you. Mr. Howard, please.
Third arrest. Last was 2009 in Michigan. Operating a vehicle while intoxicated and suspended license. Those were convictions. And the 07 suspended license conviction.
Okay, thank you. And whose case is this? Oh, Miss Alexander, is this your case?
It is.
Good to see you. Very long. Lots of people I haven't seen in a long time. Good to
I
see
know
you.
it. I know, right? Well, it's good to see you, Judge. The state is going to recommend as to count 1, we're going to remain as set on that. It looks like there was a $3,500 good on as to count 1. As to count 2, again, we would recommend that remain as set, a $1,500 good. As to count 3, remain as set. That looks like a $1,500 good. And the state went ahead and added the DUI less safe. We would recommend $1,000 good for a total, Your Honor, of $7,500 good. with conditions of an ADET, random drug and alcohol screens, no driving unless lawfully permitted to do so, and of course, no alcohol, drugs, or weapons while out on bond. Your Honor, bear with me on these facts. They are a little lengthy. On March 24th of 2022, Roswell PD responded to the intersection of Waleo Road and Azalea Drive in Roswell, Georgia, of course, located in Fulton County, in reference to a vehicle that had actually struck a pole. Upon arrival, law enforcement observed the defendant sitting on the guardrail with her vehicle over the curb and facing east. When the defendant admitted to the car being hers, law enforcement, of course, could smell a strong odor of alcohol coming from her breath as she spoke. The defendant's speech was slurred. She did have bloodshot eyes. When asked where she was coming from, the defendant first responded with the doctors and then switched that story to the friend's house. Law enforcement then spoke with an eyewitness, Miss Kennedy Prendergast, who called this incident in. The witness actually advised that she saw the defendant driving west on Azalea Drive, making a wide turn and then striking a nearby curb and then pole. Law enforcement, of course, did observe yellow paint on the defendant's car. Asking the defendant again what had happened, she did admit with a smile on her face that she struck the pole. When asked where she was, the defendant was unsure. While they were looking for the driver's license, law enforcement observed a bottle of Hennessy in her purse. Some of the residue actually transferred to the law enforcement's fingers. When asked how much she had to drink, the defendant did admit to having one drink of Hennessy from the newly discovered bottle. She then admitted to taking 3 sips of Hennessy after work. The defendant consented to field sobriety. During the test, the defendant swayed, missed heel to toe, raised her arms for balance, made improper turns, took the incorrect number of steps. Of course, the defendant was later arrested. A judge and the Georgia implied consent was read. The defendant did consent to a state-administered chemical test of her breath. That BAC was 0.225. Judge, as you've already heard from pretrial, this defendant is a multi-state offender. She does have that DWI out of Michigan. For those reasons, Judge, we would recommend that at least as to counts 1, 2, and 3 remain as set, as they do, appear to be fair and reasonable in light of the charges.
All right. All right, thank you, Ms. Alexander. Ms. Jenks, good to see you as well. Do you
Yeah.
represent Ms. Kennedy?
I do, Judge. Judge, we're
And-
asking.
Go
I'm
ahead.
sorry.
Yes, go ahead.
We're asking you to consider reducing the bond from what has been set so far, Your Honor. Miss Kennedy is a resident here of Atlanta. She has 2 children. She's an 18-year-old and a 15-year-old. Both daughters live with her. Her 18-year-old also has a 6-month-old grandson, who's her grandson. The 3 of them do live together, and she does help support them. We're asking Your Honor to consider reducing these bonds to $1,500 for the DUI and $500 for the DUI per se, and $500 for the other 3 charges. She does work full-time at Waffle House as a server, Judge. She's been working there for the last 6 years. Obviously, we heard from pretrial that she does have a prior DUI, but that was 13 years ago. And for those reasons, Judge, we're asking you to reduce the bond in this case.
All right. The bond will be so reduced as I indicate now. Count 1 will be a $2,000 surety bond. Count 2 will be $1,000 surety bond. Count 3 will be $1,000 surety bond, and count 4 will be $1,000 surety bond. That should be a total of a $5,000 surety bond. I am going to order the ADET. She will be subject to the random screens. She is to not drive unless she has a driver's license issued by the DDS, and she is to have no weapons, drugs, or alcohol as a condition of this bond. And please check my math. I believe that all equals 5,000. I'm terrible at math, so.
That's correct, Judge.
Any other questions or comments from either party?
No, Judge.
No, Judge.
That does appear to be correct.
All right, thank you. Best of luck to you, Ms. Kennedy.
Thank you.
All right, who do we have next?
Next, we have position number 15, Ms. Williams.
All right, good afternoon. Are you Nikita Williams?
I am.
All right, Ms. Williams, your case number is 22 CR 001710G, in which you're charged with 1 count of driving under the influence of alcohol, and 1 count of failure to signal when you're making a change in lane or a turn, each with offense dates of October 1st of 2021. I've advised you of your constitutional rights. Do you understand them?
I do.
Do you object to the video hearing today or to your attorney assisting you by video?
Absolutely not.
All right, thank you. I appreciate that. Mr. Howard?
6 total. Last arrest was March 22nd. This month. Suspended registration.
Wait, March
2018.
22nd? She was arrested 4 days ago? That's this arrest, correct?
This in Lawrenceville. This Lawrenceville PD.
Okay. Great.
2018 DUI. That's DUI under the influence of drugs. Suspended license arrest. 2012 DUI conviction. 2010 DUI conviction out of the cab. And another 2010 DUI conviction.
Same.
Okay.
It's the same.
Hold on, let me see.
I'm sorry, Judge, could I ask you to repeat that? The jail was calling me literally, and they also asked that you guys allow room 2 to be let in to the Zoom call, but they were giving me some instruction. I just missed the rundown of the priors. I apologize.
Okay.
Rachel. All right, let me
There
start
was
over.
quite a few. I think we got to 4. Okay, go ahead, Mr. Howard.
Yeah,
Please start over.
All right, so 2010 June 2010 DUI conviction. July 2010 DUI conviction. 2012 DUI conviction. 2018 DUI drug suspended license arrest. And March 22nd, 2022 Lawrenceville suspended registration. That's it.
Okay. All right, Ms. Alexander?
Thank you, Judge. And yes, the state is going to recommend as the DUI less safe, a $9,000 good bond, and as to the failure to signal lane, Judge, a $1,000 good bond, making that a total of a $10,000 good with the conditions of an ADET, random drug and alcohol screens, of course, no alcohol, drugs, or weapons while out on bond, and no driving unless, of course, permitted to do so. Judge, the reason for the $10,000 good bond, Judge, is because of the defendant's priors. Clearly, the defendant poses a risk of reoffending, considering her history is made up, by my count, almost exclusively of DUI convictions and arrests. This does appear to be her 5th in life, 2nd in 5. Judge, briefly, on October 1st, 2021, at Jonesboro Road, at Conley Road, Atlanta, Georgia, located in Fulton County, law enforcement were dispatched to a car crash. Upon arrival, the at-fault driver was identified as this defendant. While changing lanes from the inside lane to the outside lane, the defendant struck a car. That car struck another car. It ended up being a 3-car accident, Judge. While speaking with the defendant, her eyes were bloodshot and watery, and her speech was slurred. Law enforcement, of course, could smell alcohol coming from her breath. She did appear to be unsteady and was holding on to objects so as not to fall. The defendant did consent to a preliminary test of her breath, which did in fact yield a positive result of alcohol. The defendant was arrested. The Georgia implied consent was read. The defendant did consent to a blood test and was transported to the Atlanta Medical Center. While receiving medical treatment, law enforcement did explain to her that they were going to release her on a copy of charges, and then all of a sudden she took off on foot from the hospital, Judge. So clearly, the state has some concerns in terms of, this defendant being a flight risk, the nature of the charges, and currently, her history as it is, Judge. That is the basis for the good bond in this case.
Okay, thank you. Ms. Jenks?
Thank you, Judge. Miss Williams is a 60-year-old woman, Judge. She is originally from Dallas, Texas, has lived in Atlanta since 1994. She does have community ties here. Her sister, Amy Dell, who she's very close with, does live here in Atlanta. She has gone to school, Judge. She has worked on her towards her bachelor's degree in computer science. She currently is working as a contractor, helping to rehab houses. And rents a home with 3 other roommates, Judge, here in Atlanta. We're asking you to reduce the bond from where the state is now situated in terms of the $9,000 or $10,000 bond. That's tantamount to no bond for Miss Williams. We're asking you to allow a $2,500 bond on the DUI and a $1,000 bond on any accompanying charges.
All right, thank you. I have a question, and I should have clarified this earlier. On the last case, I did order the random screens, but I gave her a surety bond. So there was nowhere, and there's really nowhere for a place for anyone to conduct those. So I believe I'll have to strike that from our last case. Once they're released, they're not reporting to anybody. So from the last case, I will strike the random screens, and this defendant as well will not be subject to the random screens, but she is going to have a $5,000 surety bond for count 1 and a $2,000 surety bond for count 2 for a total of a $7,000 surety bond. She's not to drive unless she gets a license issued by the Georgia DDS, and she's to have no weapons, drugs, or alcohol. If the state is aware of a place for a person who is not on any type of reporting to conduct random screens, I'm not opposed to that, but I've checked with pretrial, and I don't think that we know of another place to get that done. So I will strike that from the last order, and it'll be struck from this as well.
Fair enough. Thank you, Judge.
All right. Best of luck to you, Ms. Williams. I believe that will conclude your case. Who do we have next?
I believe that's it from the sub annex. I'm not sure. I just got 2 more ladies that came in, but they might be for the felony calendar.
What are their names? We can check.
Okay.
The only person that you might have is Miss North, and she's for the felony calendar.
Okay, and what about Miss Aston?
Aston, I don't know about Miss Aston.
Okay. All right,
All right,
thank you.
South Annex can be excused. Have a great weekend.
You too, Your Honor. Bye-bye.
Take care. Bye-bye.
You owe me lunch for that, Milton.
Your
All
Honor,
right.
Your Honor, please handle my lightweight.
I've got you. Don't worry. All right. Who do we have next?
Good morning, Your Honor. Can I have Miss Jinx to call in? Well, I can call her. I have Miss, what's her name again? Davidson. I have Miss Davidson. Who is handling Miss Davidson's case?
I am.
Who is I?
Attorney Helen, if you give me the number that you're at, I can give her a call.
You already talked to Miss Davidson. So I'm just trying to get her in front of the judge. I have 2 to talk to Miss.
Okay, that makes sense. Let's do everyone to whom Miss Helen is assigned while Miss Jenks is on the line, so we can keep moving. All right. Who do we have? So we're doing position 6 and 7. Is it Shadarius Davidson?
Correct.
Okay. Your case, you have 2 cases pending before me today. You all did not hear your rights, so please, all defendants in courtroom 2, please pay attention. I'm Judge Melanie Williams. Your case, not your case. You have an absolute right to remain silent. Anything you say regarding the facts of the case can and will be used against you. You also have a right to an attorney at this proceeding. This entire proceeding is being broadcast over the internet as a live stream. It's also being recorded. That means that any member of the public can log on and watch this particular proceeding. All right, your case is 22 CR 001711H, in which you're charged with theft by
Washington, yes, it is.
Okay, you're charged with theft by shoplifting, obstruction of a law enforcement officer, and criminal trespass and damage to property. In your second case, you're charged with willful obstruction and driving or fleeing or attempting to elude an officer. The first case, your offense date is March the 23rd of 2022. And in your second case, your offense date is March 25th of 2022. Do you understand your constitutional rights? Can we be unmuted on courtroom 2? Do you understand your constitutional rights?
Oh.
You do not understand your rights?
Oh.
Okay, I'll repeat them again. You have a right to remain silent. Do you understand that?
Yes.
Anything you say can and will be used against you, and you understand you have a right to an attorney today. You understand that?
Right.
All right, do you object to me meeting with you by video today? Can we conduct this by video?
Can we conduct this?
Can I hold this hearing? Can I speak with you by video today?
Yes.
And can your attorney help you by video as well?
Who is the attorney?
Your attorney is Miss Helen. Miss Helen, will you waive?
Okay. Hello.
Can Miss Helen help you by video today?
Yes.
Thank you. Mr. Howard?
Third arrest. Last arrest was back in January, hit and run. May 2020, false statements or writings. That's open in Superior Court, 20 CP 191811.
Okay, thank you. All right, Ms. Reiser?
Yes, Your Honor. The state's bond recommendation in regards to the first case on theft by shoplifting, the state would recommend a $2,000 good bond. On the criminal trespass would be a $2,000 good bond, and on the obstruction, a $2,000 good bond with a stay away from the Texaco located at 3330 MLK Junior Drive, Southwest Atlanta, and to have no drugs, alcohol, or weapons while out on bond. The state's recommendation is based on the fact that she was at this Texaco. She took a Gatorade without paying. She also knocked over food stands and damaged some food products and drinks while inside. When the officers began to talk with her, she informed the officers she was not going to go to jail and shut her car door and drove off recklessly through the parking lot. Your Honor, she does have 2 open cases. So I think not only do the facts hint that she is a danger to the community, but also that she will reoffend if she's, let off on a signature bond. In terms of the second case, Your Honor, for the obstruction, the state would recommend a $2,000 surety on that, and on the fleeing and eluding, that would also be a $2,000 surety. So with both cases, I believe that's $10,000 total, with the same conditions of no drugs, alcohol, or weapons while out on bond. For the second obstruction and fleeing and eluding, Officer Boatley of the Atlanta Police Department did attempt to do a traffic stop on the defendant's vehicle due to her active warrants in the first case. She would not comply with their request to pull over, so they decided to not pursue. And then later they saw her again and they had to do a pit maneuver to get her to stop. At that point, she was arrested, and we believe that the $10,000 surety is reasonable in this case, Your Honor.
All right, thank you. And to clarify, in the first case, she damaged, you said she knocked over food stands. That was the damage to the property?
Yes, Your Honor. And she also, she knocked over the food stands and damaged some food products and drinks that were on the shelves.
Okay. All right, thank you, Ms. Helen.
Yes, Your Honor. Ms. Davison is 28 years old. When this event happened, she was working for a company of CHEP as a utility worker. Prior to that, she was working in a food service industry for the last several months. She is a high school graduate. She is a lifetime resident of Georgia. I do not believe she'll be a flight risk because of that. She also has strong family ties here in Georgia. Currently, she has no children. Judge, when I spoke to Ms. Davison, at this point, she's lost her job due to incarceration. So effectively, any bond, especially one of $10,000, is a no bond. Judge, I am asking for a signature bond for Ms. Davison. When I spoke to her, she stole nothing. She stated that she had paid for some gas and there was an argument with the gas station attendant, but that she had properly paid for her items and she was asking that business to give her the things that she had bought, Your Honor. So I'm asking for a signature bond for Ms. Davison. For the first case, I am asking for a total bond of no more than $1,500. That's $500 on each of those charges, Judge. The second case, I'm asking for a bond of no more than $1,500, given if Judge feels that she is eligible for that signature bond.
All right, thank you, Ms. Helen. Okay, this is an interesting one here. All right, for the count 1 in case ending in 17118 for the theft by shoplifting, Ms. Davison is going to receive a $500 surety bond. For the obstruction, she's going to receive a $500 surety bond, and then she'll receive a $1,000 signature bond through the jail. That should be a split $2,000, I believe. All right, and she is to stay away from that Texaco station and have no weapons, drugs, or alcohol. For the case ending in 17138, Ms. Davison is going to receive a $2,000 signature bond through the jail, $1,000 for each charge. All right, does that, with the same no weapons, drugs, or alcohol? Are there any further questions from either party as it pertains to Ms. Davison's case?
No,
Just
Your
to,
Honor.
just to
Oh.
clarify, it still would be $1,000 surety.
Yes.
So do
She
you
still
get that,
has
Ms.
to-
Davison? Yeah. Just wanted to clarify.
Your Honor, I'm sorry, on the first case, is it 1,000 or is it 2,000 surety? Can you break those numbers down one more time for
Oh,
me?
no, you're asking me to break and do math, Ms. Riser. It is Saturday. Okay, I believe I said 500 for each charge
Okay,
in surety and then 1,000 for the last criminal trespass. That's the signature bond through the jail. So I split the bond on case 6, case 7, she gets a full signature through the jail. All right, so she's gonna have to bond out for $1,000. All right,
Thank you for the clarification, Judge.
all right, no
How much-
math, no math.
How much was it, $1,000 to bond out?
I'm sorry, was there a question at courtroom 2? It
Yes.
sounded like it involves math. What was the question?
Give me that total amount of bond you need to bond out on.
She's gonna have to come up with 1,000 for surety. For case 7, I gave her a $2,000 signature bond through the jail. And
Right.
she also has $1,000 signature bond for case number 1. All right, so the total bond should be 4,000. Of that 4,000, 1,000 is surety.
Thank you. That's what I was trying to clarify. Thank
I'm
you.
sorry, I'm not, please don't ask me to add things together. I
No,
am,
I got
that
you. I just
really
wanted-
is not my
I just wanted to
strong
make sure
suit.
that's what you had, what you had said. Thank you.
Yes, it really is not my strong suit. All right, best of luck to you. Can we move to the next case?
Yes, we
please?
can. I'm going to try to move to Mr. What's his name? Cornell. Who's,
Position 5,
Mr. Cornell is Miss Helen's case.
That's correct.
where is Mr. Cornell? Please move quickly. Thank you. Mr. Cornell, your case is 22 CR 001709D, in which you are charged with driving under the influence of alcohol less safe, driving with defective headlights, possession of marijuana, possession of drug-related objects, and possession of open container of alcohol, each with offense dates of March the 25th of 2022. Do you understand your constitutional rights?
Yes, ma'am.
Do you object to your attorney, Ms. Helen, helping you by video today? Is that yes? No? Oh, he's muted. Please unmute just for a second. And do you also object to me conducting this hearing by video? Is that okay? Oh, I believe you're speaking, but we're still muted at courtroom 2. Will you please unmute just for one moment? Well, sir, will you just nod your head? Is it okay for me to do this by video? Okay, thank you. Mr. Howard?
Fourth arrest. Last arrest was June 2021, Cherokee County. DUI, misdemeanor obstruction, possession of a Schedule I controlled substance. 2015, Cherokee County. DUI, play a NOLO. And he got alcohol and drug treatment with that one, according to the GCRC. 2008, fleeing officer arrest.
That's it?
Yes.
All right, thank you. All right, Ms. Reiser?
yes, Your Honor. The state's bond recommendation as to count 1 DUI less safe, it's set at a 1,000 surety. The state's asking to bump that up to a $5,000 surety. On the no headlights, it's currently set at $150 surety. That can remain as set. For possession under an ounce, it's currently set at a 500 surety. That can remain as set. For the possession of drug-related objects, it's currently set at a $1,000 surety, which can remain the same. And for the open container, the state is requesting a $1,000 surety with the conditions of no drugs, alcohol, or weapons while out on bond, and no driving unless permitted by DDS. Your Honor, Officer Basco conducted a traffic stop on the defendant's vehicle for having no headlights. The defendant was slurring his speech, admitted to having 2 beers, did field sobriety evaluations, and after those evaluations was placed under the arrest for DUI. He did refuse the state administered breath test. After he was arrested, he did admit to having marijuana in the car. A search of his vehicle showed that he was in possession of 13.6 grams of marijuana, a grinder with marijuana residue inside, a glass bowl with residue, a digital scale, and a rolling tray. He also had an open container of Jack Daniel's whiskey in his vehicle. And Your Honor, the state is recommending this bond based on the facts of this case, as well as his history. Out of his 4 arrests, 3 now are DUIs. He's out on bond for a DUI, and he has a prior conviction. Your Honor, so I think it's clear he not only presents a danger to the community, but he has proven that he will reoffend while he's on bond. So the state is requesting the surety bond as recommended.
Thank you, Ms. Helen.
Yes, Judge. Mr. Connell is 31 years old. He was working prior to being incarcerated at USBCG, which is a consulting company. He has a bachelor's from Chattahoochee Tech High School graduate. He is a lifetime resident of Georgia, Judge, so I don't believe he's going to be a flight risk. He does not have any children, but Judge, he is out on bond in Cherokee County. I have heard his history. We did discuss that. That is more incentive for him to come to all of his court dates. I believe that this person is going to come to all of the court dates that are set by this court. That's why we are asking, Judge, for a signature bond for Mr. Connell. He wants an opportunity to get out, handle these cases outside. And he's stating that we would like to move for the DUI, driving under alcohol, for a $1,000 surety. The driving, the defective no headlights, please keep it as is, the $100.50 surety. Possession of marijuana less than an ounce, $500 surety. We're asking that be kept as the same. Possession of drug-related objects, $1,000 surety, kept as the same. And we're asking for the possession of an open alcohol container be set at $500 surety. I do believe that'll be $3,150. Again, Judge, he understands that he wants to get out and handle these cases, Judge, and he wants to be able to do that with the signature bond. If not, be granted a surety bond of $3,150.
Okay. Okay, Mr. Jordan, you're indicating that he has additional cases that weren't added to here. Can I handle those now?
Oh, sorry, Judge. That was supposed to be for Ms. Jinx.
Oh.
Sent it to the wrong person.
Okay, thank you. All right, at this time, Mr. Connell is going to receive a $3,500 surety bond for the DUI. The no headlights or defective headlights will be a $500 signature bond through the jail. The possession of marijuana will be a $500 surety bond. The possession and use of drug-related objects is a $500 surety bond. And the possession of an open alcohol container, that's $1,000 surety. That should be a total of a $5,000 surety and a $500 signature. He is to have no weapons, drugs, or alcohol, and no driving without a valid license issued by the Georgia DDS. Are there any comments, changes, not changes, but comments or questions?
Yes.
No, Your Honor.
You went
Your
kind of
Honor.
fast with those amounts. Could you do it one more time?
Yes, Ms. Reiser, was that your question as well?
No, I had a different question, but I figured it out right before I was going to ask it.
Okay, so he's getting a $500 signature on count 2. On count 1, it's $3,500. Count 3, $500. Count 4.
Your Honor, I got you.
You got it?
I don't have it, but I don't have the calendar, but I have like what he's charged with, his offenses. Like
Okay.
Under influence, what is that?
Okay, DUI, $3,500.
Surety.
Surety.
I do. Got it.
Driving, no headlights, $500 signature. Possession, $500 surety. Possession of the objects is a $500 surety. An open container is $1,000. That should be a total of a $5,000 surety bond.
And then
Thank you.
All right, any other matters that need to be taken before we close Mr. Connell's hearing?
No, Your
All right.
Honor.
no, Your Honor.
All right, best of luck to you, sir. Who can we take next?
No.
Come on up, Mr. Martin. Mr. Martin is next, Ms. Jinks, client.
I'm sorry, did you say Martin or Marsh?
Martin.
Okay, position 13.
Have we done Ms. Marsh yet? She was at Union City.
No, I have a Marsh and I have a Martin. I just wanted to clarify. And neither of those, there was a Charlie. This is
Marsh.
Daryl Martin. Okay, are you Daryl Martin?
Yes.
All right, Mr. Martin, your case is 22 CR 001703J, in which you're charged with simple battery against a person who was either 65 years or older or pregnant at the time of the offense, with an offense date of March the 13th of 2022. Do you understand your constitutional rights? Yes? Oh, you're muted.
You're
Can you
muted,
mute?
Judge.
Okay, there you go.
Yes, thank you. Can I conduct this by video?
Yes,
And can your attorney assist you by video?
she can.
All right, thank you, Mr. Howard.
We got over 30 total between Georgia, Missouri, and North Carolina.
Okay, most interested in violent FTA probation violations.
Last 2015 simple battery family violence, possession of a firearm by a convicted felon or felony first offender. 2015 battery conviction, 01 ag assault false imprisonment conviction. It's the Georgia history. He was arrested in the early 2000s in North Carolina for communicating threats. In the 90s in Missouri for assault. That's all that I see.
Okay, thank you.
Hold on. Yeah, that's all.
All right, Ms. Alexander.
Thank you, Judge. The state is going to recommend a $5,000 good bond with the conditions of a one-day anger awareness class, no further contact with the victim in this case, and I'm going to spell it. It's DHARAMVIR, and the last name is BALYAN, and a stay away, Judge, from 560 North Main Street, Alpharetta, Georgia. That appears to be a Chevron, Judge, and no alcohol, drugs, or weapons while out on bond. Briefly, Your Honor, on March 13th of this year, Alpharetta PD were dispatched to the Chevron at that incident location located in Fulton County in reference to a fight. The victim employee advised that the defendant struck him in the jaw and shoved him to the ground when he was asked to be respectful to another Chevron employee. The incident was also, of course, captured on video, and the victim did advise that he was, in fact, 78 years old at the time. Judge, the basis for the high bond, Judge, is in reference to this defendant's significant history. This is a convicted felon whose, I would say, violent history stems back nearly 37 years. Some of the charges, Judge, I cannot even sound out. Clearly, Judge, this defendant, it poses a significant and clear danger to the community. He does pose a risk of reoffending considering his lengthy criminal history, Judge, and of course does appear to be a flight risk. I am seeing FTAs in his history, Judge. So for those reasons, we asked for that $5,000 bid.
All right, thank you. Ms. Jenks.
Judge, thank you. I just wanted to ask one question to clarify. The state said that there was an FTA. The most recent criminal history that I heard from Tucson was from 2015. Did I mishear that?
I'm showing an FTA from 1994 and FTA from 1998.
Okay, so it's a long time ago. Great, thank you for that. Judge, we're asking for you to consider a signature bond for Mr. Martin. It seems like it's been about 7 years since his prior criminal history. Mr. Martin has completed high school, Judge. He does work full-time for as an operations manager for Three Diamonds car detailing company. He's got children, Judge. He's got a stepdaughter who's 16 years old, a daughter who's 17 months, and also his nephew lives with him. He helps to support all of them. He's got family here, Judge. He's lived here for the last 30 years. He's got two sisters that live here in Atlanta, one of which he actually takes care of. She's got fibromyalgia, so he's a caretaker for her. Aside from his job in car detailing, he also has a side gig as a pressure washer, which is why he was actually at this gas station to begin with. This is a gas station that Mr. Martin has repeatedly in the past bought water for his pressure washing business with the approval of the owner of the gas station. He's done that for a long time, Judge. In fact, on this day in question, he had actually filled up his 250-gallon tank of water several times before this last time that he was there to do so. And just to give you a little context, Judge, it takes about 45 minutes to fill up one of these very large tanks of water. Everything was going just fine on this day until actually this alleged victim started with Mr. Martin. And so, Judge, we maintain that this is something in self-defense. This is an act in self-defense. This alleged victim got very aggressive with Mr. Martin. His wife was also there. He's a partner in the pressure washing business. We're asking Your Honor to consider a signature bond in this case. If you're inclined to do that and want a little bit of extra sharpness to the hook, you can step him up a level with pretrial, but we are asking you to consider a signature bond in this case, Judge.
Thank you. At this time, Mr. Martin is going to receive a $4,000 surety bond. He is to have no further contact with the victim, last name Baylon, and he must stay away from that address on North Main Street in Alpharetta. He is to have no alcohol, drugs, or weapons as a condition of this bond. Is there anything further from either party?
No, Judge, thank you so
No,
much.
Judge.
All right, best of luck to you, sir. Who do we have next?
What's your last name?
Right.
Mr. Lyman?
All right, Mr. Lyman, position 11. Mr. Lyman, your case 22 CR 0017088Y, in which you're charged with 1 count of battery family violence, 1 count of criminal trespass, each with offense dates of January 23rd of 2022. I've advised you of your constitutional rights. Do you understand them?
Yes.
Do you object to this video hearing today?
No, ma'am.
And can your attorney assist you by video?
No, ma'am.
Your attorney cannot assist you, or your attorney can assist you?
I'm here attorney.
I'm sorry,
I'm here attorney.
you don't have an attorney?
I spoke to him, Judge.
Ms. Jenks, you represent him, correct? You spoke with Ms. Jenks. Can Ms. Jenks assist you today?
Yes.
Okay, thank you, Mr. Howard.
9 total. Last arrest was February 2020. Misdemeanor obstruction, trespass, family violence, cruelty first degree in the first degree, felony terroristic threats. That terroristic threats was Gayla Hamilton, I think, if I'm not mistaken. Got a January 2020 simple battery DV. Gayla Hamilton is the victim in that one, according to the warrant. 2014 simple assault, family violence. 2011 trespass conviction. That's it. And it shows that he's homeless.
Thank you, Ms. Alexander.
Yes, thank you, Judge. As to the battery family violence, the state is going to recommend an $8,000 good bond. And as to the criminal trespass, Judge, the state is going to recommend a $2,000 good bond for a total, Judge, of a $10,000 good, with the conditions of a 1-day anger awareness class, a third-party transfer of any shared children between the parties, Judge, no further contact with Miss Gayla Hamilton, and a stay away from 419 Lucky Street, Northwest Atlanta, Georgia. And of course, Judge, no alcohol, drugs, or weapons while out on bond. Judge, briefly, on January 23rd of this year, APD officers were dispatched to 419 Lucky Street, Northwest Atlanta, of course, located in Fulton County, in reference to a domestic dispute. The victim in this case, Miss Gayla Hamilton, did advise that the defendant and the father of her children came to her apartment and struck her in the face, leaving her with visible bruises, not and with such force, Judge, that it broke her glasses. She did advise the defendant has repeatedly shown up to this location, that she's had previous TPOs against this defendant. Judge, clearly this defendant poses a grave risk to this victim, as pretrial has already indicated, and it matches what the state has. Judge, we are seeing those two open cases, both with the same both with the same victim against the same defendant. Judge, I'm seeing that in the December of 2019 case alone, that he allegedly threatened to kill this same victim. That's the basis for that felony terroristic threats, Judge. So for those reasons, we do feel that a higher good bond, Judge, is warranted in this case in light of the significant risk of reoffending, the danger to the community, danger, of course, to this victim, and witness intimidation, Judge.
At this time, I'm going to sound for the victim, last name Hamilton. Ms. Hamilton, if you're present on the Zoom conference, I don't see anyone with that name, but I'm going to sound anyway. This is your opportunity to speak. All right, hearing none. Ms. Jenks.
Thank you, Judge. We're asking you to consider a much lower bond in Mr. Lyman's case. Again, a $10,000 bond for where he is financially is tantamount to no bond, Judge. He did graduate from high school. He completed 2 years of college. He currently has been working in a warehouse for a mattress company, Judge. He's been doing that for the past 15 years. He does have 7 children. The eldest is 19. The youngest is 3 years old, Judge, and he does provide some financial support to those children, Your Honor. He does have an address, his mother's address, where he can get court notice. And again, Judge, we're asking you for a much lower bond in the amount of $2,500 for the battery and $500 for the criminal trespass.
Does he share children with the victim? That part wasn't clear to me. Or any
He
of the
does,
7 children?
Judge.
He does.
Yes,
Okay.
Judge. I'm seeing 4 children that are shared, Judge.
Okay, 4 children shared. All right. At this time, Mr. Lyman is going to receive a $6,500 surety bond. That's $5,000 on the battery, $1,500 on the criminal trespass. He is to have no further contact with the victim, last name Hamilton. He can arrange transport through a third party only. He is to stay away from the address on Lucky Street. Should he have any items there, he can return one time with a member of law enforcement to get any items that may still be there. He is to have no weapons, drugs, or alcohol as a condition of this bond.
You ought to give me the bond amount again, please.
$6,500, $5,000, and then $1,500. $5,000 for the battery and $1,500 for the criminal trespass.
Thank you kindly.
Thank you. All right, I believe that will conclude Mr. Lyman's case. Is there anything further from either party?
No, Judge.
Thank you.
All right, best of luck to you, sir. Who do we have next?
Mr.
In
Washington.
medical, we have Darwin Jackson, but I'm not sure of his position number.
Oh, okay, we're taking the medical position.
Position 9, can I get an opportunity, a breakout to speak with medical? He wasn't made available to me prior to just now.
Okay, is it Mr. Jerome, will you put them in a breakout? Is that possible? And then we'll go back to courtroom 2. What position is that?
Mr. Washington. We have Mr. Washington.
Okay, Mr. Washington was reset from yesterday. Okay. If I remember correctly, Mr. Washington had several cases on the calendar yesterday, and those were all reset. Do we know, is this the only case before me today? Ms. Alexander, are you?
Judge,
It
that's
should
what
be a
I'm
total
seeing.
of 3, Judge.
I'm seeing,
So I just said that I add on the calendar.
yes,
Oh,
Somehow
I'm
the
just
other
seeing
calendar.
position 14.
I'm not sure that I have the add-on calendar. Hold on.
I just emailed him maybe like 5 minutes ago.
Oh, okay. Give
So
me
can we cross out number 14, Michael?
yesterday he had several cases, so I'm assuming that all of the cases.
14 is good, but he has 4 cases also.
Okay, you got 4. Okay.
Is it the same
Yes.
cases from yesterday? No, I don't have
They are,
yesterday.
Judge.
Yes, he's been reset
Okay.
since Thursday.
That's what I thought. I
Yeah.
recalled there will be several cases for Mr. Washington.
Good.
Yeah.
Mr. Washington, please bear with me one moment. I have to pull up your other cases. All right.
Judge, same thing. I'm just now seeing this.
Yeah, so it
Let me
should be a 1687, 1694, 1695, and 1696.
Okay. Oh, I see the add-on calendar. All right. All right, Mr. Washington, you have several cases before me today. Your cases are 22 CR 001695G, in which you're charged with soliciting a pedestrian soliciting rides or business with an offense date of October 28th of 2021. You also have a case 22 CR 001687G. I will not sound that offense, with an offense date of March 22nd of 2022. You also have, let's see, a case ending in 1694G, in which you're also charged with soliciting rides with an offense date of November the 5th of 2021, and the same charge with an offense date of October the 12th of 2021. Do you understand your constitutional rights?
Yes.
Do you object to this video hearing today?
No.
Can your attorney assist you by video?
So since her whole. No.
Your attorney cannot assist you?
My attorney could assist.
Thank you. All right. Ms. Alexander, I know you might, do you still need a moment? Were you able to find that?
I was able to find it, Judge. I'll go, if it's okay with you, Judge, I'd like to start with the first position on the add-on, the one for which I will not sound.
Okay.
The state will recommend, Judge, a $3,000 good bond with the conditions of course, no alcohol, drugs, or weapons while out on bond. And Judge, did you want me to go into the facts in this one or no?
Can we be put in a breakout, please?
Sure.
Me, Ms. Alexander, Ms. Jenks?
You gonna give her the history while you're in the breakout?
I can,
Okay,
absolutely.
cool.
Yeah,
That's a
yeah.
lot, yeah.
Thanks, Tucson.
How many more they got?
I don't know, unless we came up with you.
I'm just wondering how many, what, how many refresh?
I don't know. How many did you do?
Yeah, because when first started, I know they started.
I didn't bring it down. But quite a few.
And then the three that I did back there, because they were trying to add on North. Because she had got in, a couple days before, so she might get a UJ out, because
All right, has Ms. Jenks returned from the breakout? All right, there's Ms. Jenks. Thank you. All right, Ms. Alexander, I understand for the add-on one, you're requesting a $3,000 surety. What were the requests for the other cases?
That is correct, Judge. And for the other two cases, Judge, the state is going to recommend a $2,000 good for each of those, Judge, and the conditions of, again, of no alcohol, drugs, or weapons while out on bond.
All right, thank you. Ms. Jenks?
Yes, Judge, we're asking you to consider a much lower bond in this case. Mr. Washington completed 10th grade, Judge. He does actually currently work at Publix in the deli department. He's been doing that for about 3 years, although it's part-time. He makes about $620 a month working part-time at Publix. He does have an uncle here in Atlanta. He's from Atlanta, Judge, or living in Atlanta. We're asking you to consider a $1,000 bond on the first charge and a $500 bond on all of the subsequent soliciting charges.
Okay. All right, thank you. All right, for the case in add-on one ending in 1687G, that's gonna be a $2,500 surety bond. And he is to have no weapons, drugs, or alcohol. For all other cases, that will be a $500 surety bond with the same conditions. All right, anything further?
That's it from the state. Thank you, Judge.
All right. Best of luck to you, Mr. Washington.
Your Honor, we're going to, I have a question. When you was doing Union City, did you do Miss Marsh, Charlene Marsh?
Oh, I have a Charlie Marsh, ending in 1702C. We did not do that defendant.
I've spoken to her, Judge.
So that person was transported to Union City. I thought she was in that.
She wasn't, because the only other people that were on the screen had different names. So is it possible for us to, I guess Union City is gone.
Yes, ma'am.
Ms. Jenks, do you want to waive her appearance today?
Judge, are you sure she's at Union City? Because I got her.
I don't know.
I spoke to her in the mix of the males that I spoke to initially.
So she's not there at courtroom 2. They're saying that she's not there.
In between things going on in courtroom 1 and 2, transport came, picked her up and took her to Union City. I don't think Sergeant Schofield realized she was gone until after she was already gone.
And she's not reached Union City yet, correct?
We called and nobody's answering the phone. So there's a classroom that they utilize for court. So nobody's answering the phone in that classroom.
Okay, the only choices we have will be to reset her to Monday, which I don't love. And if you haven't spoken to her and affirmatively waived her appearance, we can't really do that either. So
Right, I mean, I've spoken to her, Judge, in terms of
Right, but
bond
you didn't-
argument content.
Right, I
but
understand she has a right to be here and she didn't waive that right. So unfortunately, we're not concluded the calendar, are we? We still have positions 1 and 2.
Miss Helen is talking to one of her clients. That's why I was interjecting my thought.
You're okay, I understand.
So,
Thank you for that.
And another question is, Miss Benton, Phyllis Benton. I'm not sure if she's in the jail at all. I don't know if she made bond or not. She was in central holding. I don't know if that means that she was made bond on her chart.
Does anyone else know what happened to Benton position 2?
Judge, the last time I checked was this morning and this afternoon, and it's still showing she's in incarcerated.
Okay.
So I'm sorry, Judge, if you can just clarify what your proposed course of action is with Miss Marsh, because I'm pretty upset to hear that she was taken when everyone should have known she was on first appearance this morning. So I really don't want to see her reset for another 2 days, it won't be until Monday.
The problem is if she hasn't waived her rights to be here today or spoken to you such that you could tell me she's affirmatively waived those rights, I'm not sure what other remedy I have, Ms. Jenks. And I'm
So I-
open to dynamic solutions, but she has to tell you, I'm waiving my right to be here, and you would have to submit that waiver, and I don't think you can do that because we all thought she would be here today. I'm willing to ask the jail to continue to call, and we check, and we're not finished.
Yeah, Benson
So,
bonded out, Judge. I just looked it up.
okay, well, but that takes care of Benton, but Marsh, that's still a problem. I don't have another dynamic solution unless someone else has one.
Well, I know that the deputies or someone at the, some jail staff are able to contact whoever the transport officer is, either by cell phone or whatever means they have of communicating with those vehicles. So I would ask Your Honor to ask that individual to find out exactly where they are in terms of their path of transport, so we can know if we can handle her case today rather than reset it until Monday.
Will you all do the best you can to get a hold of someone such that we can get Miss Marsh? Yeah, I'm sure that you will. And I believe, but if we don't get her, Ms. Jenks, there's not a whole lot else I can do.
Right, so let me go make the call.
Thank you. Do we have another position we can take in the meantime?
Another update, Your Honor, I do believe that Mr. Jones, Cameron Jones is in the same situation with Ms. Benton is. I'm thinking he has bonded out, and Ms. Helen said she wanted to talk to him as well.
What position was that?
I'm not sure what position. It's
No, I don't see a Jones on this calendar.
Yeah, he already bonded out. I got his file on my desk.
all right, so that take care of that. So once Ms. Helen comes out of the breakout session, we'll have that and medical, and we'll try to call South Annex again to see if we can facilitate something.
Thank
Ms.
you. And even if there's a phone number where somebody could at least speak, that defendant could give Ms. Jenks a call. And in these extreme circumstances, I would allow you to say that your client has orally told you she would waive her appearance, Ms. Jenks, just so that we could set the bond. I'd be willing to do that. But you have to have some type of contact with your client today, okay?
That's fine, Judge.
All right, I guess we're in a very brief recess until Ms. Helen returns.
Judge, we're ready on Jackson if you all are ready.
I'm ready. All right, we can go to Mr. Jackson. That was the position at medical, correct?
Yes, Your Honor.
All right, good afternoon. Are you Darren Jackson? You are?
Yes, ma'am.
And Mr. Jackson, can I conduct your hearing today by video?
Yes, ma'am.
I want to make sure you understand you have an absolute right to remain silent. Anything you say regarding the facts of your case can and will be used against you. You also have a right to an attorney. Is it okay for Ms. Helen to represent you on video today?
Yes, ma'am.
All right, thank you. Mr. Howard?
16 total. Last arrest, 2019 forgery in the 3rd degree. On probation for that in Paulding County. 2019 FTA ag assault, 19 SC 165903. 2018 probation violation. 2018 ag assault, it was reduced to battery. 12 months, it says. 2018 theft by taking, got another fade to appeal, 2017. 2017 probation violation, theft by receiving, giving false name, reckless conduct, possession of cocaine, possession of a firearm during the commission. 2014 theft by receiving conviction. 2011 FTA for battery, 06 simple battery conviction.
Okay, thank you. Ms. Reiser?
Yes, Your Honor. The state's bond recommendation would be a $10,000 surety to have no further contact with Limilton, Limelton, Reeves, Reeves, no drugs, alcohol, weapons while out on bond, Your Honor. The defendant had punched the victim in the face and caused a swollen lip and hand. At the time that this accusation was drawn earlier this morning, that was the only information we had. However, since then we have received the incident report, and this defendant had actually struck the victim with a crowbar in the face. So we will be possibly referring this up for prosecution with the DA's office. However, the state's bond recommendation based not only on these facts, you heard his history, 16 cycles. There is violent history in there. Also, most importantly, he has 5 FTAs and 3 VOPs from what I counted. So not only does the state believe that he is a flight risk based on these FTAs and VOPs, but he's also a danger to the victim. And we would request this $10,000 surety bond, Your Honor.
Thank you, Ms. Helen.
Yes, Your Honor. Mr. Jackson is 37 years old, and currently he is a proud father of 4 children that he does act as a primary caregiver of. 2 13-year-olds, 1 boy, 1 girl, 1 10-year-old girl, 1 8-year-old girl. And since he's been incarcerated, he's lost all ability to generate income for that family, Judge. So we're going to ask for a significant modification from the state's recommendation to a recommendation of no more than $3,000 surety, Your Honor. And I understand his history. I do hear his history, but Mr. Darwin Jackson, as I spoke to him, has no idea who Mr. Reeves is. And when I spoke to him, he was still almost confused as to even the allegations. So I informed him of what those were. And Judge, we are just asking again, he be given the opportunity to get out on bond and to be able to return back working and return back to his family. He is not a flight risk. He does have family ties of a aunt, Miss Thompson, who lives in Georgia, who has been a lifetime resident herself. So we do believe he will report to those court dates when given.
Thank you. At this time, Mr. Jackson is going to receive an $8,500 surety bond. He is to have no further contact with the victim, last name Reeves, and to have no weapons, drugs, or alcohol as a condition of this bond.
And Your Honor, I did forget to mention, I would be asking for a stay away. The address would be I'm sorry, give me 1 second. It will be
Is this Mr. Reeves? Oh, Ms. Reiser, I believe is frozen.
1313 Sylvan Road. This was I think this is a place where the incident took place. And I believe that the victim and the defendant frequent there often. So we would be asking for that stay away.
All right, and he has to stay away from 1213 Sylvan Road, the incident location.
I'm sorry, Judge, that's 13. Let me get those numbers again.
It's not 1213?
It says 1313.
And what type of business is that?
I believe based on the incident report, it is I'm sorry, Your Honor. I think it is a car shop or a garage.
Okay. Okay. All right. And is there a name? I just want to make sure that this is not like a medical facility or anything like that.
Yes, no, Your Honor. It is drive rate auto sales. Well, that's
Okay.
where, no, sorry, that's where the incident, yeah, occurred right there. Drive rate auto sales at that listed address.
Okay. All right. I believe I've concluded all things that pertain to this case. Any further questions?
No, Your Honor.
All right. Best of luck to you, Mr. Jackson. We can move to the next case. If there is another case we can go to. We're still holding, is there an announcement for position 1?
Go on 8,500. Needs help getting out?
I have position 1 as a loan out to Grady.
That's what I was wondering, because no one mentioned that. Does anyone else have that? So I'm assuming position 1 will be reset. Reset medical.
Yes.
Yes,
328.
Judge.
Okay, so reset to C calendar 328. And is there any announcement from courtroom 2 or what about position 8? Keenan Drake?
Did that go to felony?
No, this one is a misdemeanor charge. He does have a felony case though.
Is there any announcement on position 8?
That was not on our original pool sheet for Mr. Drake. It was actually a Jones. So if we can get an opportunity, if that person comes today to speak with them, we can move forward.
Okay. And courtroom 2, was there any luck on the young lady headed to South Annex? I'm sorry, Ms. Helen, you were saying that the person named Drake might actually be the person named Jones? Did I
No,
misunderstand?
I'm saying that the calendar has mentioned Drake. That was not on our original 14 people pull sheet. It was actually a Jones. I can get the name for you.
Okay.
I have a Cameron Jones instead of a Drake. And then the next person I have is Jordan. And then it proceeds Kennedy, Lyman, Marsh, Martin, Washington, Williams. I don't have a Drake.
I got Drake for number 8. He
I'm
went
in
to
courtroom
felony.
2. We had position 8 went to felony.
Well, he had a felony case. So
Okay.
they already did him.
Your Honor, I don't have a calendar. So
We're inquiring about Keenan Drake. Apparently, there's also a misdemeanor position, even though he might have been taken to felony.
I left the pull sheet over in felony courtroom. I apologize. As you know,
Okay.
we're working with a skeleton crew. So I've been working in courtroom 1.
I understand.
When transfer came to took the lady, we must not have, they don't come looking for us. If nobody's in your courtroom 2, they just take the lady. And unfortunately, I haven't been able to reach anybody to get Mrs. Charlie Marsh. So
Okay.
I left my calendar and notes for felony in the other courtroom.
Okay, will you just check on Keenan Drake for us?
Okay.
And we're
Yes.
all willing to hold. We haven't been here an hour and 30 minutes, so we can hold for that announcement if
Awesome. I'll be
you
ready.
want to go get it. Okay.
Thank you.
Thank
I was
you.
going to say I didn't know if it would help her. I have the jail activity report. That's not the pull sheet she's looking for, right?
No, I have the pull sheet.
Okay.
What I'm going to retrieve is the calendar.
Oh, I got you. Sorry. Okay.
So he has a warrant from 9/1/21 that looks like he was just left off the misdemeanor full sheet because he was
Yeah.
stuck on the felony.
Yes, that's correct. I got that email added, like the add-on, probably around lunchtime.
Do we want to review the calendar in the
Yes, I was
meantime?
just about to suggest that.
Okay.
Yes.
Jordan, will you review the calendar for us while we hopefully get hold of the other position?
Position 1, I have reset to the 3/28/22 SCA calendar. Position 2, May bond, reset further notice. Position 3 is a 2,500 surety bond. Position 4 is a $500 surety bond. Position 5 is a 6,000 split. It was 5,500 surety and $500 sign-on bond jail. Position 6 is a $2,000 split bond, 1,000 surety, 1,000 sign-on bond jail. Position 7 is a $2,000 sign-on bond jail. Position 9 is a 8,500 surety bond. Position 10 is a 5,000 surety bond. Position 11 is a 6,500 surety bond. Position 13 is a $4,000 surety bond. Position 14 is a 500 surety. Position 15 is a $7,000 surety. Position 1 on the add-on is a 2,500 surety. And positions 2 and 3 are 500 surety bond each. And all the cases are being reset to 4/7/22 SAP calendar.
Can you give me the add-on announcements again?
Position 1 was a 2,500 surety, and that was case 1687G. Position 2, case 1694G, was a 500 surety, and position 3, case 1696G, was a 500 surety.
Thank you.
Any comments, changes, corrections, or questions? Oh, courtroom 2 is back. Any announcements?
Yes, Drake was upgraded to felony. He was position 38 on their calendar for theft by receiving, no insurance, and fleeing or attempting to elude.
So it seems, Ms. Reister, so he does not have a pending misdemeanor charge at all?
No.
They were all upgraded?
No, Your Honor, he does have a pending misdemeanor. It was a warrant that was issued on September 1st, 2021. He does have bonds set already in this case for 2,500, but this case is still a misdemeanor.
So does he need to be brought today, I guess is the question. I'm assuming if bond is set, he doesn't have to be brought.
He does have bond set, Judge, and that, let me just double check.
And Ms. Helen and Ms. Jenks, you were not aware of this particular case and would need to speak with that defendant?
Correct.
Correct.
Okay, he has a bond set. We will reset him unless he can be brought now. Is that possible?
I have staff running all over the place. It's just me.
Okay, so this sounds like that's not possible. So he'll be reset to Monday's SEA calendar as well. And the young ladies on the way to the South Annex. We were not able to get any response.
No, I called 3 different numbers, 3 different locations of Union City Jail. Still haven't gotten an answer.
And how long have they been in jail? How long has she been in jail? This will be day 2.
I'm sorry, I don't have that information.
I'm trying to look, not necessarily you. Does anyone know how long Ms. Marshall's been in jail? Or was she booked in? Was it yesterday?
I'm looking now, Judge.
I think it was the 25th.
All right, I don't think I have any other choice but to reset that case as well to Monday. Unfortunately.
Judge, that is correct. She was booked in on March 25th. She's been in custody for 2 days.
will be coming up on a Riverside issue.
That's correct, Judge.
I'm aware of that.
What was the
I
time
hate-
again?
We're coming up on her being in there more than 72 hours.
So what?
She was arrested at 3:51 a.m. So
Of yesterday.
yeah, so Monday at 3:51 a.m. that would be.
Right.
That'll still be a problem. We really need her today.
I can keep trying.
Keep trying. Let's give this another 10 minutes or so,
Okay.
everyone. All right. Thank you. No one has the cell phone number for Deputy Bogle by any chance? All right.
So Bogle doesn't actually have a cell phone. He's been using my county issue cell phone and I have it on my person. Right. I mean, we do things, but we try to make do. We gotta get it done.
I understand. We're really in a rock and a hard place here. How long until she would arrive at South Annex? Is she already she's in transport? Okay.
I have none of
Okay.
the information.
We really need to try to hear this case today, so let's give it a little bit longer. I'm willing to wait if we can get it done.
Okay.
Thank you.
Is Drake gonna be Riverside too?
I thought that was upgraded to a felony.
No.
No, Drake has a bond. Drake has a bond, so we're okay.
Drake has a 2,500 surety bond right now.
Marsh does not have a bond.
Correct.
All right.
So Judge, he hasn't been heard on the first appearance on that warrant. This is the original arrest on that warrant. But he didn't come in until the 26th. So he's good for a reset on Monday.
Okay, that's Drake,
I think it was
correct?
just right. He was just left off the misdemeanor count, full sheet by mistake because he had all the felony charges. And they missed that one misdemeanor charge.
Okay,
So the bond was given at the time the warrant was written. He hasn't had a first appearance on the case.
oh, so we would have the same issue.
I think he was brought
Well,
in.
no,
on
he has a
26th.
bond though. He has a bond, so we should still be fine to reset him.
Well, he still hasn't had his first appearance. The bond was written at
Yeah.
the time the warrant was issued.
Oh, I see what you're saying. So we're
Yes,
gonna have
Judge,
the same,
Drake would still need a first appearance as
that's
well.
the same problem.
And he was brought in at 8:17 p.m. on the 25th. So by
Okay.
Monday, he will have hit his 72 hours also.
Right then. Yep. Okay, well, we're gonna ask if it's possible to bring Drake, if there's nothing I can do. Quite difficult to administer justice today.
And nobody answers then that last time she answered.
The tower,
Sergeant McCoy,
the tower.
I don't know. I just dialed the number.
All right, apparently we do have the same problem for position 8, Mr. Drake. Is there any way possible he could be brought today?
So Drake needs to appear. He was,
Drake needs to appear, have his first appearance.
he's not on the pool sheet, but,
That's the gentleman that was on the felony pull sheet. If they could if he could be brought.
oh, he's in intake. He's going to, medical.
Who's,
to finish felony.
who's the
So-
person?
Drake, first name, I'm sorry, what's his first name?
Keenan George Drake. And he would have to have an opportunity to speak with his attorney as well.
Give me a booking number. Give me a booking number, please.
2204-356.
Okay, so I got Sergeant McCoy at Union City finally answered. She's gonna go back to the classroom where they hold court via Zoom, and she has to log into that computer. It is
Okay.
a Superior Court computer, so she may have to ask somebody else to help her log in. Everybody just can't log in on that computer. So she's
And
gonna,
so that's why we are willing to wait now. And can Drake can we still see Drake today as well, Mr.
Yep.
Drake?
Sergeant Schofield is looking him up in Odyssey to see where he's located to get him in before the camera.
All right, thank you so much. We're gonna take a 5 to 10 minute break.
Can I have a phone number of somebody, because Drake needs to be interviewed correctly? Am I correct?
Yes.
Sure, you can call me.
And what's the number? Ms. Jinx.
Yeah, I got it.
404, you got,
Sergeant Schofield has it.
okay, cool,
Thank you.
thanks.
Sarge. Sergeant McCoy. Do the unmute, it's gonna be a mic that says, volume. You see the mic, it has a red line in between it. Don't sit down right there. All right, Your Honor, we're ready for both.
Yeah, I'm ready for Mr. Drake, Judge.
All right, we'll take Mr. Drake first, and we'll take Ms. Marsh. All right, good afternoon, Mr. Drake. Your case is 22 CR 001715B. I'm Judge Melanie Williams. In this case, you're charged with 1 count of theft by taking, which was a misdemeanor, with an offense date of September the 1st of 2021. You have an absolute right to remain silent. Anything you say regarding the facts of the case can and will be used against you. You have a right to an attorney, and Ms. Jenks is available to assist you. I'm conducting this by video. Do you object to the video hearing? Do you object to Ms. Jenks assisting you by video? Mr. Howard?
31 total. Last arrest was April 2020. Financial transaction card fraud. That's open in the cab. 2019 criminal attempt to commit a felony conviction. 2019 entering auto dismissed. 2018 probation violation. 2018 armed robbery, hit and run, possession of a knife or a firearm during the commission, ag assault, and another possession of a knife or a firearm. Well, no, I'm sorry. Possession of a firearm by convicted felon. 2018 theft by receiving. 2016 shoplifting conviction. He got a probation warrant out of Douglas County, I see. And he got FTAs as well.
Okay, thank you. Ms. Reiser?
Yes, Your Honor. The state's bond recommendation, I know I stated that his bond, Mr. Drake's bond is currently set at 2,500 surety. The state would recommend an increase to a $5,000 surety with the conditions of no further contact with the victim, Derek Hansford, HANSFORD, and stay away from the incident location of 330 Ethan Allen Drive in Atlanta. Your Honor, briefly the facts of this case, the defendant went to the victim's home address at that Ethan Allen Drive. The victim had a utility trailer parked at his house. The defendant had a U-Haul truck pulled up to the victim's house and attached that trailer and drove off with the U-Haul. Your Honor, we're requesting this $5,000 surety bond, not only because of the facts of the case, but you heard his history. It's very extensive with 30 cycles. Multiple cycles include violence. Other cycles include similar cases as the one before you, as well as there were some FTAs and some VOPs. So not only is he a risk to the community or danger to the community, but he is a flight risk, Your Honor. So we would ask for that $5,000 surety.
Thank you. Ms. Jenks?
Thank you, Judge. Mr. Drake shared with me, he's a 41-year-old man. He is born and raised here in Atlanta, Judge. His parents, he lives with his parents in McDonough, Your Honor, and he works for their company, which is called Drake Signs, Inc. He applies decals. He's been doing that part-time for the last 17 years. We're asking, Your Honor, to allow the bond to remain at that $2,500 amount.
All right, thank you. The $2,500 surety bond will stand. He is to have no further contact with the victim, last name Hansford, and he is to stay away from the address on Ethan Allen's Drive. He is to have no weapons, drugs, or alcohol as a condition of this bond. Anything further from either party?
Nothing from the state, Your Honor.
All right, best of luck to you, sir. Let's move to South Annex. Ms. Marsh. Ms. Marsh, your case is 22 CR 001702C, in which you are charged with DUI, less safe, DUI driving with possession of an open container and making an improper use, each with an offense date of March the 25th of 2022. Do you understand your constitutional rights?
Yeah.
Do you object to this video hearing today?
Yeah.
Thank you. And can your attorney assist you by video?
Yeah.
Thank you. Mr. Howard,
You're muted.
if you're talking, you're muted.
I was. Second arrest, 2005, misdemeanor possession of marijuana.
Okay, thank you. Ms. Alexander?
Yes, Judge, the state is actually showing a little bit of a different criminal history there. I'll go into that in just a second. The state recommends, Judge, a $3,000 good for the DUI alcohol less safe. As to the possession of open container, the state is going to recommend a $1,000 good. And as to the making improper U-turn, Judge, the state is going to recommend a $1,000 good with a total good bond, Judge, of $5,000 with the conditions of an ADET, no driving unless, of course, permitted to do so by DDS, and no alcohol, drugs, or weapons while out on bond. Judge, we're showing 20 cycles for this defendant. But I'll briefly go into the facts. On March 25th, 2022, while on patrol, Roswell PD observed the defendant making a prohibited U-turn at 1360 Holcomb Bridge Road, Roswell, Georgia, located in Fulton County. Despite clearly visible signage denoting that this U-turn was in fact illegal, law enforcement initiated the stop because of that. While speaking with the defendant, her speech was slow and slurred. Her eyes were glassy and had a strong odor of alcohol coming from her car. When asked to step out of her vehicle, the defendant appeared unsteady on her feet and did sway left to right. The defendant consented to a field sobriety test. During the exam, Judge, the defendant could not focus or keep balance. She missed her heel to toe, stepped offline, and made improper turns. She then admitted to having consumed 2 glasses of wine about 1.5 hours prior. The defendant was arrested, Judge. The Georgia implied consent was read. During the search incident to arrest, law enforcement did in fact locate an open Kettle One vodka bottle under the passenger seat and a shot glass in the center console. Judge, from what the state is seeing, this does appear to be 20 cycles. She does appear to be a clear risk of reoffending. Considering that, we are seeing multiple probation violations, recent convictions for driving related offenses, Judge. So for those reasons, that's why we are recommending that good bond.
And Judge, before I make a bond argument, I'd just like to inquire as to the discrepancy between the history report for pretrial and what the state says they have. My client has shared with me that she did have that one prior arrest, but nothing other. So it's possible the state does not have the correct criminal history for Ms. March.
Mr. Howard, you want to confirm perhaps date of birth to make sure you all have the same person?
State, tell me what you have for date of birth.
For date of birth, we have 4/24/1981.
What's the last 4 of the social you have?
Let's see here.
Because I got single state offender.
You have
with
a single
this being
state
her
offender?
second. Yes.
Okay, let me see here. I'm looking. I'll have to go back and look through here. Let's see.
So the last 4 of the social I have is 9360.
Okay. And it's possible they could have uploaded it improperly.
They do me like that all the time.
Wait, what did you say the last 4 were? 9360?
Correct.
That's what we have in the system. I'm going to go ahead and look really quickly on the GCIC run. Yep. And the GCIC has a different number on here. So the state would stand corrected on that and would defer to pretrial.
Okay, so we'll accept the history as given by pretrial, Ms. Jinks.
Thank you, Judge.
Thank you, Judge.
Judge, I've spoken with Ms. Marsh. She shares that she's a 40-year-old woman. She's been in Atlanta since 2000, Your Honor. She has graduated high school. She did complete a year of college. She's been working as a chef for a staffing agency over the past 2 years and doing that full time. She does have 3 children, a 13-year-old, 12-year-old, and 9-year-old. All 3 children do live with Ms. Marsh, as well as her sister, who also lives with Ms. Marsh and her children. We're asking Your Honor to allow a $2,000 bond in the DUI, a $500 signature bond on the other 2 infractions that accompany the DUI.
All right, thank you. At this time, Ms. Marsh is going to receive a $3,000 surety bond for count 1. a $1,000 surety bond for count 2, and a $1,000 signature bond through the jail for count 3, for a total of a $5,000 bond. 4,000 is surety, 1,000 is signature. She is to not drive unless she has a license issued by the Georgia DDS. She is to have no weapons, drugs, or alcohol as a condition of this bond. Is there anything further?
No,
Nothing
Judge.
further, Judge, thank you.
All right, I believe this concludes our calendar. We will all be in recess until Monday, the 28th, where I believe Judge Morrow will be presiding. If there are any outstanding orders that I need to sign, please send them to Mr. Jordan. Otherwise, the rest of you all have a great weekend. Courtroom 2, were you asking for something before we left?
I just want to say a round of applause to Sergeant McCoy. She kind of saved us today. Thank you so much.
Thank you.
Thank you,
You get the
McCoy.
Snicker bar, Sergeant McCoy. You get the Snicker bar of the day. Thank you all. And thank you for everyone for your patience. There was quite a few issues today. Thank you to everyone at the jail for running around making those calls. We really appreciate it. All right, everyone, take care. Have a great afternoon.
You not
too,
here
Judge.
Monday?
Thanks.
Thank you, Judge.
I'm not
Have a
here
great-
Monday. Judge Morrow
It's
will
not
be here
him.
on Monday.
He said it wasn't him.
Oh, he's back on. It was going to be Judge Mincy, but he'll be here on Monday.